This was a pretty brutal filing. The expectation that you've set for everybody else is that not only will the case obviously be won by Pxie, but I'm going to be in the hole for millions and millions of dollars because of like how I am. Hey, Andrew, why don't you guys sit this one out and let the expert, the D to the S and Destiny, and take care of this one, Chief? Like, what is... This was a pretty brutal filing. 12 pages, no exhibits. I guess there's not much to respond to because they didn't really put much in their reply besides their weird expert witness guy. Is the lawsuit 100% over? No. I mean, if the judge dismisses it on this, which now I'm feeling like there is... Before I was like, the chance of winning on a dismissal for a case like this, I feel like a pretty low. Like it's more like a summary judgment kind of thing. But now I'm not sure. Now I feel like there's like an okay chance of it actually just getting straight out dismissed, just because their response was so bad. It was such a bad response. Okay. Our reply. The court lacks subject matter jurisdiction over this dispute. The plaintiff's opposition offers no evidence whatsoever to cure that fatal defect. Indeed, in the court's October 6, 2025 order denying plaintiff's motion for preliminary injunction, Magistrate Judge Torres warned that if plaintiff cannot show in due course that the conduct alleged is indeed covered by the statute, it is possible that we do not have subject matter jurisdiction over plaintiff's case. Plaintiff's opportunity to establish jurisdiction has come and gone. The burden rests on her to establish jurisdiction, yet since filing the complaint in February of 2025, plaintiff has failed to produce any evidence to demonstrate that Vinal transmitted the video after the effective date of the Cardi statute. The record demonstrates that Vinal sent the video on a single occasion to a person named Rose in April 2022, months before Cardi took effect. Despite having nearly 8 months to conduct discovery, plaintiff has failed to proffer any evidence to the contrary. Notably, in just the last few weeks, and with the discovery deadline looming, plaintiff is scrambling to establish subject matter jurisdiction, engaging in a frantic fishing expedition, including by seeking relief under the Hague Convention to obtain wholly irrelevant documents from Vinal's ex-wife in Sweden. Plaintiff should have established subject matter jurisdiction before filing her lawsuit in federal court, rather than desperately seeking evidence of jurisdiction 8 months later. Having failed to meet her burden, plaintiff's claims must be dismissed. Plaintiff submits with her opposition a declaration from a purported expert, Jesus Peña, who falsely opines that Vinal has tampered with evidence in this case. Shockingly, however, Mr. Peña's testimony is not even his own. He plagiarized his sworn testimony by copying and pasting verbatim from a third party's post on Kiwi Farms, the same website that published the video in November of 2024. Worse, Mr. Peña unsuccessfully attempted to conceal this fact. Then, just 2 days ago, on October 8th, 2025, without even attempting to meet and confer with Vinal's counsel, plaintiff filed an untimely motion seeking to amend Mr. Peña's declaration, disavowing and retracting many of his baseless conclusions of evidence tampering. The court should disregard the Peña declaration entirely. 2. Plaintiff has failed to establish subject matter jurisdiction. Where, as here, a defendant mounts a meritorious factual challenge to jurisdiction under Rule 12b-1, the burden shifts to the plaintiff to establish jurisdiction by competent proof. See this case, dismissing complaint, where plaintiff failed to offer affidavits or testimony after notice of a factual jurisdictional challenge. Plaintiff must respond to a jurisdictional challenge with admissible evidence, not speculation, to sustain jurisdiction. Quoting another case, the non-moving party may not rest merely upon allegations in the pleadings, but must set forth specific facts showing the court has jurisdiction. Despite having been on notice of a jurisdictional defect since the beginning of the case, plaintiff has failed to submit any evidence of Vinal's alleged post-Cardi transmission of the video. In her opposition, plaintiff relies on Lawrence v. Dunbar to argue that dismissal under Rule 12b-1 is precluded because the jurisdictional facts are intertwined with the merits of plaintiff's claims. They are not, and in any event, Lawrence expressly holds that federal courts have the inherent authority to resolve factual challenges to subject matter jurisdiction under Rule 12b-1 unless the factual challenge implicates an element of the cause of action. This is just basically saying, like, when can you challenge things in a motion to dismiss? How is the court going to look at it? Because the timing of the April 2022 transmission has no bearing on whether Vinal's alleged conduct meets each element of Cardi, Rule 12b-1 governs, and dismissal is proper. Alternatively, dismissal is warranted pursuant to Rule 56 as plaintiff has failed to establish a genuine dispute of material fact. Even if jurisdictional facts were intertwined with the merits, plaintiff still cannot survive dismissal under a summary judgment standard. Plaintiff cites no evidence establishing a genuine dispute of material fact, and, critically, under Rule 56, a non-moving party's failure to submit any evidence establishing a dispute of material fact warrants summary judgment and dismissal. There is no dispute that the transmission of the video to Rose preceded the effective date of Cardi. The evidentiary record, including Rose's leaked Discord communications log, conclusively establishes that the video was transmitted to her in April 2022, nearly 6 months before Cardi took effect. Plaintiff has submitted no evidence to dispute that fact. Rose's side of her communications with Bonnell was accessed and leaked by a third party who, being located in a European time zone, downloaded the messages such that the timestamps are reflected in the European day, month, year format. The leaked Discord log shows the message dated 10/04/22, meaning April 10th, 2022. Bonnell's own logs confirm the video was sent April 9th, 2022. In her opposition, plaintiff submits no evidence to the contrary. 2. Plaintiff's ever-evolving continuous disclosure theory fails as a matter of law. In her amended complaint, plaintiff alleges, without any factual or legal basis, that Bonnell transmitted the video to Rose via a Google Drive link, and that such a transmission somehow constituted an ongoing dissemination or continuous disclosure of the video, sufficient to establish subject matter jurisdiction. Now that the record affirmatively demonstrates that Bonnell never sent the video using Google Drive, plaintiff has abruptly modified her theory. In her opposition, she now concedes that Bonnell transmitted the video on one occasion via Discord in April 2022, but she asserts that even a private, one-time media attachment constitutes a continuous disclosure under Cardi. Plaintiff's ever-evolving theory is entirely unsupported by law. Indeed, the leaked communication logs show Bonnell's subsequent communications with Rose reinforced the evidence that Rose's chat logs were converted into European day-month formatting, communication exhibiting a date stamp of 14/04/2022. There is no genuine contention here, obviously. Critically, federal courts have repeatedly rejected similar arguments. In Ray v. Greenberg, the court held that emailing a public link to a shared drive to a single person where no facts suggest the link was widely disseminated could not, as a matter of law, constitute an ongoing or public disclosure. The court in the companion case, Greenberg v. Ray, reached the same conclusion. Plaintiff's attempt to rebrand a single private Discord message as a continuous dissemination is baseless and should be rejected. Moreover, plaintiff's reliance on Doe v. McCoy and Doe v. Unknown Party is of no consequence. Unlike the public postings in McCoy and Unknown Party, one of these had this was the motherless posting, like literally posting these to a website. Bonnell neither uploaded nor publicly displayed the video online or in a public forum. Nothing in McCoy or Unknown Party suggests that a private Discord attachment amounts to an ongoing disclosure by the original sender. Indeed, no court has ever held that a one-to-one message, especially one sent before the statute's effective date, constitutes an ongoing disclosure under the Cardi law. Plaintiff fails to submit any evidence that Bonnell ever transmitted the video to ABMC. Plaintiff likewise offers no credible evidence that Bonnell transmitted the video to ABMC at any time, let alone evidence that could establish a genuine dispute of material fact as to such a transmission. Indeed, Bonnell's preserved logs show every file he sent to ABMC, none of which contain the video, while plaintiff merely alleges that Bonnell transmitted the video to ABMC sometime after March 2023 via a Google Drive link. The evidence conclusively establishes such a transmission never occurred. Bonnell's communication logs with ABMC demonstrate that the only Google Drive links he shared on November 3rd, 2023 contain videos of another individual, Pxie, who has confirmed the content as her own. Plaintiff's contrary allegation rests on speculation, not evidence. Plaintiff's failure to provide any evidence to support her allegations is fatal to her amended complaint. Plaintiff has had nearly 8 months to conduct discovery. Plaintiff's untimely and improper plea for further discovery cannot salvage jurisdiction and avoid dismissal. Courts deny such fishing expeditions where a plaintiff had months to develop the record, yet fails to identify the specific evidence expected to emerge. Plaintiff speculates that Bonnell sent the video to ABMC via a Google Drive link, but offers no evidence to support that claim. In fact, no evidence exists that Bonnell ever transmitted the video to anyone through Google Drive. Plaintiffs claim that the Google Drive links sent to ABMC and Pxie do not match is incorrect. The single character difference, a lowercase letter L instead of number 1, is a routine artifact of text to PDF conversion required for ECF filing, not evidence of any substantive discrepancy. Plaintiff's purported expert should have known better. Oof. Plaintiff cannot now avoid dismissal due to her own lack of diligence. Apart from issuing a subpoena to Kiwi Farms early on in this case, plaintiff has done very little in an effort to establish jurisdiction. She has failed to take a single deposition or even elicit testimony from her purported star witness, ABMC. Moreover, given that Bonnell has already produced all responsive documents in his possession, plaintiff has failed to articulate what further discovery she supposedly still needs. With the discovery deadline looming, plaintiff is now scrambling in an attempt to establish subject matter jurisdiction. In just the last few weeks, plaintiff has begun noticing depositions, retaining purported experts, and even trying to obtain irrelevant materials from Bonnell's ex-wife, who now resides in Sweden through the Hague Convention. Plaintiff's lack of diligence is fatal to her claims. Plaintiff's baseless allegation of evidence spoliation has been repeatedly rejected by the court, and the Pena declaration should be stricken. Rather than submit evidence to establish subject matter jurisdiction, plaintiff instead filed a declaration from a purported expert who falsely accuses Bonnell of evidence tampering. The court has already rejected such a contention on multiple occasions, quoting other orders, as Judge Becerra instructed plaintiff's counsel at the April 4th, 2025 status conference. The proper channel to seek sanctions for alleged evidence spoliation is by noticed motion pursuant to Rule 37E of the Federal Rules of Civil Procedure. As the court recently noted, it is now October of 2025, and there is no such motion on the docket. That plaintiff believes expert testimony is required to establish subject matter jurisdiction is telling. A party should not need an expert, even a qualified one, to determine whether her claims are properly before this court. Indeed, subject matter jurisdiction is a threshold issue that should be established conclusively before a plaintiff even files suit. Regardless, plaintiff's purported expert does nothing to establish jurisdiction here. In fact, in giving his expert opinion and accusing Bonnell of tampering with evidence, Mr. Pena plagiarized his sworn testimony. Indeed, he copied and pasted portions of his expert opinion directly from a third party's post on Pxie Farms, the very website that published the video online. Specifically, portions of paragraph 20 of the Pena Declaration are copied verbatim from the post below by Code Cave on Pxie Farms, which was published on September 20th, 2025, weeks before Mr. Pena submitted his sworn declaration. This was the copy-pasted stuff. Worse, while Mr. Pena attempted to conceal his actions by removing the hyperlink destination on one of the embedded images in his declaration, he failed to take the same measures for the plagiarized embedded image on page 13 of his declaration, which still contains the hyperlink destination to the Pxie Farms post above. On their holding that plagiarism, an expert's report warranted exclusion of expert who passed off others' work as his own, demonstrating an unreliable methodology as a whole. Moreover, just 2 days ago on October 8th, 2025, plaintiff filed an untimely motion without even attempting to meet and confer with Bonnell's counsel first, seeking to amend the Pena Declaration, wherein she informed the court that paragraphs 17 and 18 of the declaration were no longer supported. Mr. Pena submitted an amended declaration disavowing and retracting certain meritless conclusions of evidence spoliation, particularly as it pertained to transmission of the video to Rose. The Pena Declaration must be stricken and disregarded accordingly. Number 7, footnotes. Bonnell objects to the entirety of the Pena Declaration on the grounds that the witness is not qualified to testify as an expert. And then Local Rule 7.1A2 provides a failure to confer any cause for the court to deny a motion and impose on counsel an appropriate sanction. Conclusion: for these reasons, the reset for the Bonnell's motion, Bonnell respectfully requests the motion to be granted entirely. What a meme. The legal mindset. I watched some of this guy's video yesterday because he had like some other expert guy on, and I just don't know, dude. I feel like I'm going crazy. Like, I listen to these people. He's supposedly some guy who's like an expert in tech stuff, but like nobody, like I'm not like that tech savvy. Like, I know more than an average person, but these people are just retarded. It's just actually like retarded shit. Legit question: do you think having a dismissal will hurt you instead of winning on summary judgment? I could definitely see the online dump saying some bullshit on Twitter, like Doe wasn't proven wrong. That's not one of the cases because of technicalities. No. This was supposed to be, like, again, I know that it triggers the fuck out of all my haters to hear it, but like when you can't make measured criticisms of me and I'm constantly like a rapist, and it's 100% that I'm like a rapist, sex demon or whatever, then the expectation that you've set for everybody else is that not only will the case obviously be won by Pxie, but I'm going to be in the hole for millions and millions of dollars because of like how f***ed I am, like how obviously super f***ed I am. Remember, like, legal mindset and that criminally, whatever that Pxie Farms, the fat guy is, like, all these guys initially said that I was representing myself, and then they said that I was going to lose 100%, and then they started coping that, well, maybe Pxie doesn't have expensive enough lawyers, and then they said, well, this new thing is going to sink it. Like, it's just like, I would be very happy with a dismissal on this, 1,000,000,000,000%, absolutely. If the case ends up getting dismissed, what do you plan on doing afterwards? I don't know, I'm just going to take a fucking sigh of relief. Jesus. Oh yeah, this guy. Get into the digital forensics evidence with my cybersecurity expert and my IRL best friend Ryan of Elevate Cyber. This guy just sounds like a scam artist. I don't know if he's like selling something, but yeah, I don't understand how the brain breaking happens so much. It's so stupid. This guy hates me too. I'm not sure if I did something to him personally or if it's like a political aisle thing. I have no idea, but.
Yeah, this timeline's looking a little suspect at this point based on the filing of the of the lawsuit. However, it was also publicly...
It's looking a little sus. Really? A little sus? Keep in mind, we are 150 docket entries and 8 months into this case, and plaintiff has provided absolutely zero evidence on her side to establish any timelines whatsoever, but we'll go with a little sus. We call that, I think legally, I'm trying to think of what this is referred to, depending on where you practice. I think it's called cope. I think it's what they call it.
Discord was known to have a significant security issue wherein all attachments sent in messages were permanently publicly accessible from the CDN simply by navigating to a permanent web address that pointed to the attachment. Ruh-roh. See Exhibit C.
I like how he's laughing. He has no idea what he's reading, or he has no idea what any of this is saying. It's so retarded. Okay.
This is all wild stuff. And this is why I say Destiny's in some serious trouble, because if he's tampered with evidence on top of the fact he's talking with a minor, on top of all the other stuff he's doing, this is some serious problems for him. And once again, these parties, and we talked about the personalities in the beginning, both Destiny and Pxie are set on not settling with each other. They hate each other. So this is going to go to trial. So this expert witness is going to be testifying, it appears like at the eventual trial. And the problem is that I don't think Destiny has a digital forensics expert, and he's now going to need one, a person that once again could be trained by Ryan's course. We're going to talk about that later, but like he's going to need a digital forensics expert, and there's aren't that many, or it's going to be hard to find one that's going to back up his side of the story to show the...
Well, finding an expert witness is trivial, okay? The reason why we don't have one is because, and again, I don't know, maybe Legal Mindset only, does legal work insofar as he's trying to get virgin white into non-English speaking Southeast Asian women. Maybe that's the only thing he's familiar with, so anything outside of that is just outside of his area of expertise. But the reason why we don't have a digital forensics expert is because they literally just threw this one on in a response to our motion to dismiss. This is the first time a forensic expert has appeared. So obviously, if we went to trial, we'd probably have to retain one of our own in order to, fight their expert witness, or we would try to discredit, their expert witness or whatever. I don't know what the process is for all of that. But I love how confident he's talking about the most retarded expert witness testimony I've ever seen in my entire fucking life.
Again, Destiny and Hasan, these are guys that Wikipedia everything, they Google everything. They think they're so damn smart, right? They think they're super smart, right? But they're going to screw up on a detail like this. This is a detail that you need to be an expert, right, to really catch, right, Ryan?
Yeah, for sure.
It's so ironic him saying that. Does he think I'm preparing the PDFs and the file? I'm just paying all this money to a law firm to just submit all of this myself. I'm like, hey, Andrew, why don't you guys sit this one out and let the expert, the D to the S and Destiny, and take care of this one, Chief? What a stupid... Also, the fact that he's not even looking at... I don't know if our responses come out yet by the time he posts this video, but God, he's so stupid.
Yeah, it seems like the main takeaway is that he didn't actually, his team or whoever didn't collect the evidence properly, so they didn't do the hashing. So anything that he says it's not going to be from what I understand from the legal side, it's not going to be permissible in court. I don't know if that's the right way to say it, because they can't really, they have no way of knowing if that's the original data or not.
So
you have no way of what do those words mean? It's a digital file. What does original data mean? Unless we were both working off of somebody else's copy and we wanted to create hashes to make sure we weren't altering, if we're making copies of images or something, like disk images, and then working off our own copies and, submitting those, it's the chain of custody starts with me. I can edit and change whatever I want. If you want to get originals from the original sourcer, then go to Discord, subpoena Discord. You're asking me for my logs? I can always change anything. It doesn't matter whether I hash it or not. This is such a stupid argument. This is so brainless.
So let me reinstate that, guys. What Destiny is saying is likely inadmissible. So all this shit that Destiny...
If what I'm saying is inadmissible, Plaintiff literally has less than nothing. They're not even submitting logs. They're submitting pictures of logs. How, if what I'm saying is inadmissible, then Plaintiff literally has nothing.
He's been talking because he's been running his little mouth, right? Thinking he's so damn smart, thinking he's like the king of the world. He's not. He has no friends. He's a loser, right? He's mentally... He's got some...
Oh, he's mad. Oh, he's just soft. He's in his feelings. Oh, he's in his feelings because he can't read? He couldn't read the Declaration? He doesn't know anything about law aside from fucking Southeast Asian women with his little passport bro business? Is he just upset about that, or?
He is not, a lot of this evidence he may not be able to admit into court, right? It may be inadmissible. That's a massive problem for Tiny. He's going to have huge issues here, right? And the only way to counter this is to get his own expert, which he doesn't have. There's not many of them, but he doesn't have this expert witness. This is massive.
It's not massive. What do you they threw this expert witness on 1 week ago. What? We don't even need an expert witness for this case. Now, if they want to bring one, I guess I can bring my own. Keep in mind, they still have no evidence of their own, right?
Jack Choi says, "Alizations." Shout out to actual SJW. Thank you.
All right.